Hey friends, what's going on, guys? Hi, Bougie Gang. How are you? Let me see if I can find something real quick. Oh, God, it's always something. It's always something. 23 SC 001723. Oh, okay. Order. And of course, someone always has to call. Okay, I was trying to find the order. Is this it? Okay, I've got that. Okay, so Nesto's lawyer filed a certificate of immediate review. So I was in the middle of something, and our good friend Dennis sent me a kite to tell me that there was something very important going on, and I appreciate that very much. Thank you, Dennis. Mr. Dennis Byron sent an alert to let me know, because I was damn sure in the middle of something else, but I appreciated the alert, because I was not paying attention. I had not checked the docket this morning, so thank you, Dennis. I appreciate that. Um, and I read it, and then I had to get some further understanding because I'm not a lawyer, right? So yeah, wasn't that nice? Okay. Um, and just to kind of understand, because I remember Judge Dunaway telling Nesto's lawyer that they could appeal it. So they could appeal the decision, right? Um, where is my document from? Because I don't want to have to download this again. Let me see. Order denying defendant's motion to suppress. Let me see if I just go under maybe Earnest Williams. Notice of filing. It's like I end up buying stuff like 2 and 3 times. I know I probably got it from the other. Okay, order denying defendant's motion to suppress. I'm sure I probably posted it too. Where did I put that? Ugh. I wish I would have taken 2 seconds to look for it before I went live. Anyway, let me show you this first, and then I'll see if I can find it before I just go ahead and download it again. Anywho, all right, let's get into it, guys, really quick. But if you guys recall, when Judge Dunaway denied the motion to suppress the vehicle search, he stated that they were welcome to appeal and appeal. I guess they're starting the appeal process, because I had to read about it, because I'm like, okay, well, what does this mean? And let's get into it. Hi, Kappa Man. What's going on, sir? Peace and blessing. Shout out to MOBG. MOB. What's MOBG? I'm saying I'm assuming BG is Bougie Gang, but MOBG, I'm not sure what that is. Good morning. Yes, and don't forget to go and check out our good friends over at TTP Body for your Ready Set Glow, the wonderful mask, and the beautiful body butters. Go check them out and use code Bougie10 to get a discount. Okay. Thank you for mentioning that. I appreciate that. Let's see what this document says, and I'll try and find the other one. Share my screen. Okay. All right, so this was filed today at 10:35, so last hour. It's a certificate of immediate review. The motion of Ernest Williams, a defendant in the above styled case for suppressing the search of his vehicle, having been duly presented to the court December 18th, 2024 and August 11th, 2025, and said motion being denied September 4th, it is hereby certified that the decision and the decision and order denying defendant Ernest Williams' motion to suppress the vehicle search is of such importance to this case that immediate review by the appellate court should be had. And it is signed Eric Dunaway. Now, it is being presented by Sean Hoover. So I don't know. I guess he has approval to submit this and has his electronic signature to do that. So I'm not sure who issued this. I would imagine, I'm not sure. I would imagine it's the judge. Maybe they had a conversation and it was issued. So I'm not sure how long you have from that time. Maybe it's 30 days. Let me check these were the new indictments. State's motion to join the three. Okay. Let me check the other, because I might have downloaded it from the other spot. So basically what this is, I'll tell you what this means. So I had to look it up, and what I surmised is that just a second. Is this it? No. Hold on, I'm pulling Nesto's thing up. The certificate for immediate review basically is the request for the appeal. Hold on. Okay, so the certificate for immediate review is a legal instrument used primarily in Georgia that allows a party to seek an appeal of a non-final or interlocutory court order. The trial court issues a certificate which signals to the state appellate courts that a ruling on an important controlling question of law should be reviewed before the entire case is concluded. The purpose of the certificate of immediate review, generally, appeals can only be filed after a final judgment is issued. However, in some situations, a trial court's decision on a specific legal issue is so important to the case that waiting until the end could cause significant hardship. The certificate addresses this by preventing prejudice. It allows for an immediate review of an order that, if left in place until the end of the trial, could permanently harm the party's case. Promoting judicial efficiency. It can prevent a long and expensive trial from proceeding under an incorrect interpretation of the law. If the trial court's ruling on a crucial issue is reversed on immediate appeal, it could alter the entire course of the case. Addressing controlling questions of law. It is used for legal questions, not for reviewing factual disputes. The issue must involve a controlling question of law on which there is substantial grounds for a difference in opinion. How to get a certificate of immediate review. File a motion. The party seeking the appeal must file a motion with the trial court outlining why the order meets the criteria for immediate review. This motion must be filed within 10 days of the trial court's order. Now, I haven't seen a motion filed at all, and this certificate of immediate review seems to have come out almost a month after, because we know that the motion denying the vehicle suppression was on September 4th, and that was almost a year after the motion to suppress was filed to begin with. And so Judge Dunaway made a decision almost a year afterwards. And this certificate of immediate review seems to be, the decision was on the 4th, and this certificate was issued on the 30th. When Hoover filed a motion, I don't see anything documented. I remember that Dunaway told him he could file something, but there's no documentation that that was ever done. You know what I'm saying? Like, I don't know. I don't see any motion, but it stated that they could appeal. So maybe he's already stating that he was okay, that he would have approved an appeal. I have no idea, but there's a certificate now that has been filed with his name on it. And it sounds like they're going to try to get the Superior Court to appeal, to review this particular situation, because it's a mess. Okay. And why wouldn't it be? Because since it involves Ernest Williams. In Georgia, the process generally involves these steps: filing a motion, of which we have not seen. The motion needs to be filed in 10 days. It's not on the docket. The trial court judge has the discretion to grant or deny the request. Since there seems to be an electronic signature with the judge's signature, I'm assuming that they're either granting it. I guess, I don't know. Trial court decision. The trial court judge has the discretion to grant or deny. If the trial court grants the certificate, the party then applies to the appropriate appellate court, either the Georgia Court of Appeals or the Georgia Supreme Court, to review the order. And then there is a discretionary review. The appellate court also has the discretion to decide whether or not to accept the case. So it's not just because Judge Dunaway signed off on it that the case is going to be seen by the Georgia Supreme Court or the Georgia Court of Appeals. It does not automatic. They have to review it and see if it's a case that they will review. If they do, then it goes from there. So it just, to me, it's more delay, and I guess him sitting over there on his charges and sitting on those charges. Okay, sitting on those charges and waiting for some sort of resolution to this situation. Okay. I hate when the source is because I like things, but I hate. Well, okay. So he is questioning how Dunaway interpreted the law. I guess the law is up for interpretation, right? So who is question? So Hoover. If you recall, well, he according to Nesto says the car is his. Nesto says the car is his. He had marital privileges. The car was his. Shirley knew about it, all of the things. So, yeah. Do you not recall that Judge Dunaway stated that they could appeal the decision? If he said to Hoover and Wooten, if you are not, whichever side you are able to appeal. Seems like they are giving him a fair chance, unlike what Sonia thinks and says. Yeah, I mean, a fair chance in the sense that he's going to have to, they're having to do their homework, and they're having to do their due diligence. They're having to, Hoover's going to have to earn his check. Okay. Okay. Right. It doesn't necessarily mean he's going to get an appeal. But maybe Dunaway is going ahead and signing off on it because Dunaway is like, look, based on my review, this is what I think. I'll let a higher court review it as well. Therefore, I don't have to just be the lone bad guy, and I'll have the weight of superior court judges or the Georgia Supreme Court to review it and basically co-sign my review. So there's nothing wrong with that. I swear to God, my phone could not ring, and next thing you know, okay. But we reviewed. Hold on a second, guys. Let me see if I can pull this up because I think I must have gotten it from over here. Um. Okay. So let's see. Events. Oh, are they not showing that on here anymore? What? Oh, have you guys been on Research Georgia? This is weird. I hadn't seen this like this. What? Oh, this isn't even on here yet. Okay, because I'm like, what is going on? Why am I not seeing this? Interesting. Okay. I'm still here. Okay, let me pull this down and I'll read this to you guys again. I feel like I know I have this, but I just can't find how I saved it. So I have to get it again. Okay. We talked about this a couple of days, a couple of weeks ago, actually. Order denying motion to suppress. I'm sure I have this in here. Why could I not find it? Okay. All right. Let's go here. This is the order denying, right? Okay. This is the order denying from September 4th, 2025. Are we all on the same page? Are we in the same place, guys? Okay. The above referenced case came before the court on December 18th and August 11th, 2025, for a hearing on the defendant's motion to suppress the vehicle search. As set forth below, the court, having considered the arguments raised in the motion, the state's response in opposition thereto, the defendant's supplemental brief, and the state's motion to dismiss the defendant's motion to suppress, the arguments by counsel at the hearing, and the applicable law, hereby denies the same. The factual and procedural background. Let's talk about it. This is why the judge denied it and why he stated they can appeal it if they want. In a 39 count indictment, the defendant is charged with violation of the Georgia RICO Act, false swearing, theft, identity fraud, false documents, and other related charges allegedly arising from acts being in December 2009 and continuing through June of 2022. On September 30th, 2024, the defendant moved to suppress a vehicle search and all evidence obtained from the search of a white Ford F350 by Roswell Police Department in violation of the Constitution of the United States and the Constitution of the State of Georgia. Specifically, the defendant asserts that on or about July 7th, 2022, Roswell Police Department personnel observed him park and exit a vehicle, Ford F350, at the parking lot located on Alpharetta Highway. Defendant states that he was arrested in said parking lot on a pending arrest warrant while he was taking pictures of a for lease sign. After the arrest, law enforcement impounded and towed the truck to the police parking lot. The next day, law enforcement obtained a search warrant for the truck, seized items inside the vehicle. Defendant asserts that search and seizure were performed without a valid search warrant. At the December 18th, 2024 hearing, Roswell detective Natalie Fields testified that in June 2022, Mr. Williams had multiple pending warrants for his arrest. Detective Fields further testified she observed the defendant driving the truck at issue, pulling into a parking lot, parking, exit the truck, and begin taking pictures. Detective Fields then took defendant into custody based on the arrest warrants. The truck was impounded for investigative purposes and towed to the police lot for a search warrant, and a search warrant was obtained. A copy of the search warrant was introduced into evidence, states Exhibit 1. January 6, 2025, the court requested defendant file a supplemental brief to suppress the vehicle search and all derivative evidence. In the supplemental brief, the defendant lists the evidence he contends should be excluded because of the illegal search. On January 24th, 2025, the state filed a motion to dismiss the defendant's motion to suppress on the basis that the defendant's lacks standing to challenge the search and seizure of the F350. On August 11th, 2025, the court held a subsequent hearing and showed the state to present evidence on its motion to dismiss. At the hearing, the state called Shirley Strawberry, the purported registered owner of the truck in question. The district attorney investigator, Billy Ansell, Ms. Strawberry testified that she did not purchase, apply for credit, register, sign for, or authorize anyone to sign for anything on her behalf relating to the truck. She stated she did not complete, sign, or authorize anyone to sign States Exhibit 1 for retail or vehicle credit application, the retail installment contract, and security agreement. Ms. Strawberry further testified that she knew defendant had purchased the truck but did not authorize him to use or know what he used, that he used her name or signature on her behalf. Investigator Ansell identified and introduced States Exhibits 1 through 7, particularly States Exhibit 1, the retail motor vehicle credit application, the retail installment contract, and security agreement. Based on investigator Ansell's research, all of the supporting information on the retail vehicle credit application, telephone numbers, email addresses, referencing individuals, did not relate to Ms. Strawberry, but were connected to defendant. Georgia law is clear that a defendant cannot assert a violation of his or her Fourth Amendment rights in regards to a search of a vehicle where he or she has no proprietary interest in it or legitimate expectation of privacy regarding the vehicle or its contents. On the contrary, as one knowingly using a stolen vehicle on a public roadway, a defendant probably is in constant expectation of intrusion by the authorities. They're just citing applicable law. This doesn't necessarily have to do with Nesto. This is a relatable case that they are referencing. For example, in a case involving a search of a fraudulently obtained hotel room, the Court of Appeals reasoned, although registered guests of a hotel can have a reasonable expectation of privacy in their room, one that has obtained a room by fraud can have no expectation of privacy in the room. Like one in possession of a stolen car, mere unlawful possession does not alone warrant a reasonable expectation of freedom from governmental intrusion. In this case, the evidence shows that the defendant obtained the Ford F350 by fraud. Specifically, the documents regarding the truck show it was purchased in Miss Strawberry's name, although Miss Strawberry testified she did not purchase, sign, or authorize anyone to sign anything on her behalf relating to the truck. Miss Strawberry further testified that although her signature appears on the application, she did not authorize the defendant to use her name or sign anything on her behalf. Accordingly, the court finds the defendant lacked any expectation of privacy in the seized and searched Ford F350, see Thomas versus State. In conclusion, in the light of the foregoing, defendant's motion to suppress is hereby denied. So ordered on this day, the 4th of September, blah, 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 filed and served electronically in Odyssey. Okay. He stated in open court that they could appeal. So I'm sure he anticipated this. And at the end of the day, it is what it is. I'm sure Hoover is just doing his job. No, this is not, this document is not his document. This is the order from the judge. Let me be clear. This is the order from the judge. This is the immediate, the certificate for immediate review. And that could have been sent to him by the judge because it's got the judge's electronic signature, but it says it's being presented by Sean Hoover. The judge could have sent this document and instructed him to file it on Nesto's behalf. I'm not sure how that works. That's yeah, slide back, boo. Go ahead and slide back to the beginning because there's a lot of information we just went over. So that was the original. What I just read was the original denial, the original order from the judge. This is from the judge. This is from Judge Dunaway order denying defendant's motion to suppress. This was what we were waiting for almost a year from the Honorable Eric Dunaway. Okay. That's what I just read. And this is the certificate. And what does the certificate mean? What is that noise? Hold on one second, guys. Oh, my Alexa's going off. Oh, God. I was like, what is that noise? I had set a timer for Alexa and she's letting me know. Because this was actually when I was going to go live. Let's see. Again, so you guys know, this particular certificate of immediate review, sorry guys, I'm from New Jersey. I can't say that very well. Certificate of immediate review. This is what this is. This is what was just filed. What does this mean? A certificate of immediate review is a legal instrument used primarily in Georgia that allows a party to seek an appeal of a non-final or interlocutory court order. The trial court issues a certificate. The trial court issues a certificate which signals to the state's appellate court that a ruling on an important controlling question of law should be reviewed before the entire case is concluded. The purpose of the certificate of immediate review, generally, appeals can be filed after a final judgment is issued. However, in some situations, the trial court's decision on a specific legal issue is so important to a case that waiting until the end could cause significant hardship. The certificate addresses this. Hold on one second, guys, because my Alexa is going crazy. Hold on. Y'all, I had to tell Alexa to hush. Okay. I had to tell Alexa, girl, I'm up. I'm up. I'm up. I'm up. Okay. Thank you guys for dropping your mile. Thank you. Thank you. Thank you, sir. I appreciate it. Okay. Okay. That's the update. What does this mean to us? I mean, it's probably more delays. It's going to be more delays. Probably for Nesto, but Nesto's the one who's doing the time, not us. We're free. Okay. We're out here. Nesto is they are fighting. Look, what do they say? What did we hear the other day? If you guys were in court last week, the district attorney says that when she was in law school, her professor taught her if you have the law, argue the law. If you have the facts, argue the facts. If you have the facts and the law, you argue both. If you have nothing, you just argue. And she said that's what Mr. Hoover and Mr. Arnold Regas were doing. They were just arguing. She called them out for not having anything, okay? She said they're just arguing because they clearly they didn't have the facts. They didn't have the law on their side. They didn't have the facts on their side, so they're just arguing. Okay. I was like, ooh, ooh, ooh. Okay. They're just arguing. So they're gonna just do what they gotta do. All right. Hoover is doing his job. He's doing his job. And I mean, I guess I would have expected it. Oh, I'm still not coming. Okay. That's what's going on, guys. Okay. Are we surprised? I think they're doing the next step because you know how certain things, maybe they may say, you know what, this based on the evidence, based on the amount of evidence that they may have, this may not look good because we've talked about this a few times, but there are certain things in the indictment that in my opinion, as a layperson off to the side, they could just go ahead and concede to. Okay. Was Nesto in a bigamous relationship? Well, that paperwork says so. Okay. Part of his RICO is the bigamy. So could he concede to that in theory? Absolutely. Right. Right now, you have a component of the RICO that is hinging on this vehicle search. Well, not only do you not have the ability to suppress information because it was not your truck. Furthermore, there is now evidence to support that the truck was obtained fraudulently. So you really have no standing on the evidence that was procured from the truck. Period. And it's showing that because you obtained the vehicle fraudulently from the truck, guess what you got? A whole nother case. You done caught another case complaining about the case. You filed a motion to suppress, and not only did the motion to suppress get denied, you caught another case. And then on top of that, another case, because guess what? They bought the case against the landlord, the notary, and a couple of other things. So you got the PGR new case, and then you got the Shirley Strawberry case. So it's added about 6, 7 new charges, maybe 8 charges. It's added a host of new charges to a robust RICO full of charges. Okay. So I think at this point, Hoover is just doing his job to make sure that he doesn't get a ineffective assistance of counsel. If Hoover didn't do his job, this could be a technicality that Nesto could pursue to say that my lawyer never appealed this decision because this decision got me this and this happened because of that. So Hoover, because I feel like Nesto is in such hot water, he absolutely had to do his job to file these to file the notice, because it would probably be malpractice if he didn't, or some sort of ineffective assistance of counsel, knowing that part of the RICO, even though Wooten said that he had additional evidence, there's so much more now, especially with the Strawberry indictment and putting that into the RICO, and even the PGR indictment. Some of the evidence for those indictments are information that was obtained, in the vehicle search, and he's just doing his job. I think Hoover's just kind of doing his job. He has to. I don't know how how he could get a case talking about the bankruptcy. I guess you'd have to tell me more about that. I don't know. Bankruptcies are public record. She can go on Pacer and look up Shirley's bankruptcy. I know I did. You know what I'm saying? So she could. I don't know what kind of case he would get from that unless Shirley sues him personally, but he doesn't have anything, and that I feel like that would be a waste of Shirley's money, but I don't know what other case he could get. I think Nesto filled out that paperwork. Shirley is going to say I didn't file for bankruptcy. She filed for bankruptcy. She had a bankruptcy and she didn't pay on her bankruptcy. The bankruptcy is legit. The bankruptcy is legit. She had a personal business manager in California who was the custodian of that particular bankruptcy. I think the bankruptcy was legit. The bankruptcy ended up getting dismissed due to non-payment. But it had a lot of valid information. I don't think it was a fraudulent bankruptcy. Not to mention the bankruptcy wasn't realized, like her bankruptcy wasn't discharged. There was no discharging of debt or anything like that. The bankruptcy terms were not fulfilled and they dismissed it. So, yeah. Well, they called it the Strawberry indictment. He might as well just let that go. Well, I think from a standpoint of him being his lawyer, he probably has to do the right thing, which is just go through the motions. Did I get to the part? I think I read it the first time, but let me read this again to you guys. Just because they file for an appeal doesn't mean the appeal will be heard. Okay. In Georgia, the process generally involves these steps. First, there's the motion, file a motion. The party seeking the appeal must file a motion with the trial court outlining why the order meets the criteria for immediate review. This motion must be filed 10 days of the trial court's order. So I read to you Judge Dunaway's order denying, right? I don't see any motion filed by Hoover 10 days or no days after the denial. I don't see anything. There's no motion, but okay. Trial court's decision. The trial court judge has the discretion to grant or deny the request. So based on this certificate, and it's signed by Judge Dunaway, my assumption is that he signed off for the review of the appellate court, but I don't see where Hoover filed a motion, but that's fine. That being said, hold on a second. Did I show this? Okay, so this is what's on the screen. Okay, so that being said, the appellate court's consideration, if the trial court grants a certificate, which they did because this is a certificate of immediate review, right? If the trial court grants the certificate, which he did, the party then applies to the appropriate appellate court, either the Georgia Court of Appeals or the Georgia Supreme Court, to review the order. Based on what Judge Dunaway outlined as to why he denied the motion to suppress, the appellate court also has the discretion to decide whether or not to accept it. So, based on what Judge Dunaway says over here, all of what he laid out on 4 pages, they may not take the case. They may feel like let the lower courts stand. Because not only was the car obtained in fraud, but also if he tries to claim, well, that's my wife, well, she wasn't your wife, because do we need to talk about the bigamy? You had a fraud marriage. So you can't really, oh, I didn't realize Nesta was in the way. Sorry. You can't really claim marital rights because the marriage was void. Even though there was a legal marriage that took place, the marriage was void because it was found to be bigamous. So it's kind of like he painted himself into a corner. Girl, this makes him look even more stupid. That's what Hoover was doing in the last trial. What, for trying to find a technicality? Yes. Remember we were looking and like, is he filling out some paperwork? Is he doing his Nesto homework over there? He was sitting over there doing some of his Nesto homework. Yes. Yes. When he realized that that Julian was getting ready to get an LWAP. Yes. I concur. Girl. Mm-mm-mm. Filing papers. Mm-mm-mm. Okay, so what do you guys think? What are we thinking? Look, I'm gonna just say this. You say it's stupid. Okay. Well, I do, like I said, I think that Hoover is doing his job and he's required to do his job and he is required to do as much as he possibly can to assist his client. And that way, if at the end of the day, things do not turn out in Nesto's favor, that he did everything that he was supposed to do to provide the best outcome for his client. That's what he's doing. It doesn't, I think that based on what Dunaway filed, um, if you have not heard what I said, what I read earlier about the order denying the vehicle, the motion to suppress the vehicle search, slide back and listen to these 4 pages. Dunaway didn't even give all of the information. Not to say he's withheld anything pertinent, but there's even more reasons. Like he could have even gone further down the rabbit hole, on top of the fact that even though, yes, Shirley is the defendant's wife, but he didn't even venture down the path of, and the marriage was void and the marriage was bigamous. So even from a consent standpoint, he did not have permission to use her information, apply for credit, and do all of those things. But furthermore, he wasn't even really a legal husband because the marriage was done legally. However, it was a void marriage because he was not in a position to be married. So again, false swearing, identity theft. I mean, he has racked up more charges pursuing this suppression motion than he had not. Do you follow me? Because because he decided to continue to pursue, which that's his right, he ended up with more charges, additional cases, and more charges. And on Judge Dunaway's order, my point is he didn't even give all of the reasons. I guess he gave the first and foremost reasons to why he was denying it, but he could have even gone further and deeper about the void marriage, about the bigamy, um, which he did say. This is what he did say, but he didn't go into detail. It was obtained under fraud. So once you look down the fraud, once the appellate court's like, well, what was the fraud? Oh, false swearing, identity theft, all of the things, bigamy, everything. Okay. So it wasn't just, so there's a very elaborate fraud scheme attached to the fraud to purchase the vehicle within a void fraud marriage. It's just a lot. It's a lot. I think they got so much going on with Nesto. Will the appeals court see all of that evidence through? Okay, so what this is my thought, okay? They're not going to take this whole entire case file. What they're going to This is what I think is going to happen, not what I know is going to happen, but what I think, right? You see what Judge Dunaway, let me see, are we on the right page? Hold on. Look at what Judge Dunaway identified. He says, as set forth below, the court, having considered the arguments raised in the motion, so I'm sure they're going to look at the motion. They're going to look at the state's response in opposition. They're going to look at the defendant's supplemental brief. They will look at the state's motion to dismiss the defendant's motion to suppress. And they're going to probably get the transcripts from the arguments by counsel at the hearing, right? And then they're going to review. They're not here to do a full case review, but as it pertains to this is what Judge Dunaway cited as what he used to make this decision. So they'll probably request this and anything else that came from it, maybe the Shirley indictment on top of that. Like, they're going to be looking like specific to this. This is like a one look back type thing. This is as it pertains to this matter, not his whole entire case. This is just the motion to suppress and everything that has come from it. You follow me? So I think that's what the appeals court or the Georgia, is it the Georgia Superior Court, or hold on, let me see. The Georgia Court of Appeals or the Georgia Supreme Court. One of the two will make a decision whether it's probably going to be the Georgia Court of Appeals, I would imagine. And then maybe if they reject it, maybe the Georgia Supreme Court. I don't know. Maybe it's the appeals court first. We'll take a look at it. The appellate court also, they'll take a look at it, but it doesn't mean that they're going to take the case, right? I think Judge Dunaway, because he's the presiding judge over this case, most people don't mind having someone validate what they already know. So by the judge issuing the certificate of immediate review, he's like, okay, so this will be, so right here answers our question. It's the appellate court. So he's already approving that the appellate court can take a look at it. Go ahead. And just double confirm. his decision. So I think that's basically what that is. So they'll double confirm, they'll review the file and see if it's something that they need to consider. They might send it back and say, let the lower courts stand. Like, this doesn't require our review. This is valid. Well, yeah. Hmm. Okay. Did everybody hit the like button for me? This might just be a little short. And we'll come back later. Um, okay. You think Hoover's just buying time? He's tired. Oh, well, he better, I mean, he's got some clients who need a vigorous defense and it's not time to be tired. But yeah, I feel like Hoover's just doing his job. I mean, I think that's probably just goes with the territory. Right. But even if another no comes, it's he did his job. What do you mean, where's Hoover's appeal? Right. Okay. So I mentioned that. There is supposed to be an appeal filed 10 days after the denial. There's nothing on the docket that I see. There I don't see anything on the docket. Nothing. Maybe he filed it in secret. I have no idea. It's possible cuz he does file stuff where it's you can't see it, but I'm certainly not accusing him of doing that. I've just seen that he's done that he's engaged in those type of shenanigans. So I don't know. I'm going to assume that it I don't know. I don't know. I'm going to resort it on another platform and see if it shows something. Um but he tries to file hidden documents. We know that. So only certain people, if you're probably in the district attorney's office type of thing can see that. And let's see, I'm resorting now to see if I see like a hidden document filed. It's possible. But how Dr. Charles, I'm sure there's just some things that you just have to do that's like your job. Um, like someone could choose to do this course of treatment or that course of treatment, but maybe under your license, you need to mention that there's another, like there's this choice, there's that choice, and then there's this choice, right? So maybe because this is so, this is kind of like a pivotal time in his case. He may just be doing his job. I don't know. You know what I mean? Like, I think that it just makes sense if it's Nesto's facing a lot of time, and there's already, in my opinion, there's things that are in this indictment that are already things that going into the trial that they may as well just concede to. And what I mean by concede to is we're not contesting charges number blah blah and blah blah blah. You know what I mean? Like, there's just some things that coming in the door, in my opinion, they should already just cop to and not even try to have stand there and try to defend, because you're already guilty of some things. And that is, if you're married to Edith, you are guilty of a bigamous, felonious, void marriage with Shirley Strawberry. So that's false swearing. That is the fraud of the signing of the documents. According to Shirley, she did not give you any permission, so you already have one identity theft from her. Um, Taking her information to apply for credit, all of those things, all of that whole thing is already basically been, you may as well concede to, because the judge made a decision to deny the vehicle search based on the evidence provided. And that was some of the evidence provided. So the judge had to think that some of that information was valid to deny the motion to suppress. If that information wasn't valid, then they wouldn't use that to suppress the motion, to deny the suppression of the motion. So the judge must feel like the information provided about the identity theft and the bigamy of Shirley and him not having any rights to that vehicle based on those factors is valid. And if it's valid, guess what? The strawberry indictment, that's a slam dunk right there. Now, is that enough time to put him away for a long time? No, but on top of that, there's other cases. He's got like damn 30 charges. So it's just, I think Hoover's, like I said, for probably the 10th time, I think Hoover's just over there doing his job and doing what he needs to do to not have any type of sanctions against him and his license, to make sure that he does everything he's supposed to do, so it doesn't come back on him for ineffective assistance of counsel. And Nesto could kind of squeeze through on a technicality because his lawyer didn't contest as much as he possibly could, for the evidence that is going to send him to the penitentiary. Well, yeah, so I'm sure Nesto wouldn't turn it down. He doesn't want to be in jail, and he knows that some of that evidence in that vehicle is going to run him right to one of those jails in Georgia, one of those prisons in Georgia. Hoover is probably to file any and everything so the case doesn't flop. No, technically done, done, done. Okay. I mean, really, how in the world is just Hoover going to be able to argue against the facts that Wooten put in the motion? He's gonna make it the victim's fault. We've seen Hoover's technique and how Hoover argues. He's going to put the victim He's going to measure the victim's responsibility and the victim's ability to have walked away or made another decision, and he's going to blame the victim, and that's going to go over horribly, as it always seems to do, because I've seen like 3 of Hoover's last cases, and it's failed miserably. That is a horrible way to come at the jury, by trying to blame the victims. He tried to blame a young lady who was sex trafficked for what happened to her, which I was in shock that he did that. He sat up there and tried to blame the boyfriend of the lady who lost her 8-year-old daughter for not submitting to an illegal militia who was illegally armed, who shot at the vehicle when they were just trying to get home on 4th of July, and tried to make that their fault, that they should have succumbed to a bunch of YNs holding the neighborhood hostage. Okay. And he also stood up there in open court and accused bloggers of what they did not do, trying to derail this man on the screen's case. And baby, ain't nobody do anything other than talk about this paperwork and them phone calls. Okay. I've seen Hoover time after time after time malign and accuse innocent people because someone came for them illegally and are standing in judgment, and loves to try to drag the innocent folk. So that's what Hoover's going to do, in my opinion. That's just what I've seen. If he does something different, he might want to. He came for Shirley, trying to ask her why didn't she voluntarily repossess a car. Who is going to voluntarily repossess a car? The lady makes $1 million a year. She can pay the car note now. She don't have that husband draining her account anymore. I'm sure she's got plenty of money to do what she wants now. But when he was out of jail, he was draining her accounts and running her into situations where she damn near was putting out her whole check, and she had a non-working ass husband trying to play like he was out here making money. Nobody's going to go run a car back a hot, you know what I mean? Like, even though, yes, it would make sense, but nobody wants to buy that car, and she may as well just pay it off, because who wants another bad credit ding in your, when you don't want to have it at all. I'm sure Sonia said absolutely, but I don't think Hoover's even talking to her. I think after Sonia sat up there and was reaching out to Will Wooten, I don't know that she can even reach out to those people, because remember, she was saying that she was going to run it to Joy. She was going to run something to Joy because Hoover won't take her calls. Hoover probably won't take her calls because she was sitting up there reaching out to Will Wooten. Okay. Right. Nobody, you know what I'm saying? Like, we don't know what she's got going on in her portfolio, but nobody needs, other than that, she probably, I don't know what the reasoning is why continuing to pay the monthly note rather than just try to work a deal with the lien holder and just pay it off and try to get like an early payoff discount. But who knows, girl? She probably doesn't want to. Surely that's more trouble than she needs. And I don't know if anyone wants that car. I don't know. Like, all good ideas, but we'd have to ask her. But that's a good idea, but Shirley doesn't want to be bothered. She's probably okay with just paying the note and not just charge it to the game that I should never have married that man. You know what I mean? That's probably one of those things where every month it's just a monthly reminder of, I should have listened to my first mind rather than getting caught up in the rapture of love and playing stupid. You know what I'm saying? She probably is like, you know what I'm saying? Like, it's just one of those, every month, charge it to the game. So I don't make that mistake. Just the painful reminder of what I shouldn't have done. Anyway, guys, I'm not going to hold y'all. I will definitely come back. Nesto paid too much for that. Yeah, he couldn't. It's a mess. But to the point, because I think we talked about this when Joey was here, maybe the last time, that interest rate, when I was like, but who would get that interest rate? And he said, well, if you're not going to pay for it, who cares? Right. And I'm paraphrasing. He didn't say it like that, but it was something to that effect. Like, basically, if you're not going to pay for it, it didn't matter what the rate was, because he was probably planning on defaulting on it anyway. And he didn't care, because guess what? It's not his credit. Again, he's always using someone else's credit and fucking up their credit. Meanwhile, his credit is probably like a 3 or something, just absolutely non-existent. So He didn't care what the rate was because he wasn't paying for it. And he didn't care what the rate was because whether it defaulted or not, it wasn't going to fall back on him. So that made sense because it didn't make sense to me like why someone would have a credit card rate for a car loan, which was crazy. But yeah, he would because he's not paying for it. His wife was it was coming out of her bill account. I'm sure it's one of those things that you know how where there's smoke there's fire. It's probably one of those things where they probably enter it into a database, and if there's enough complaints, enough kind of, yeah, this name keeps coming up. Guess what? Now you've got an investigation because you've got two, three, four, five situations where something like this has now come up. It's just a matter of, I'm sure in a city like Atlanta, they probably don't have enough time to investigate things like that. It's probably more so when you see some continued activity on something specific, that's when it rings the alarm. Like, you know, we've had like three, four cases complaining about um, bad information on applications, identity fraud and theft involving this particular, you know, are they facilitating this? Are they a conduit to illegal activity? And then you got a problem. You know what I'm saying? So I'm sure they're keeping an eye, not to mention when you read the reviews on that dealership, they're not good. There's so many people complaining. You look that car dealership up, it's awful reviews. We did something about it. I don't know what I called it. But let's just say this year, it might be when Will Wooten filed that report with the 277 pages. I have to find it, but I think with that report with the 277 pages, or it might not have been that one. It might have been the one when the evidence first came out with the vehicle purchase contract and that stuff. I think we looked at that dealership. I'm not even going to say their name right now because people are, you know, sometimes people are looking for a come up. The documented dealership name, I think we did a drive by um, Google search, and the reviews were horrible. So let me look on what's it called? Hold on. What was that? That was was that the supplemental discovery? No, because that should have been more pages. Let me see. If I can find which one it was, and that would give an idea of the date. Whenever that came out with that contract and we looked at it and all that misinformation, you know, the Lamont, Carlos Lamont, all that foolishness, states reply to defendants filing supplemental exhibit. Is this it? This might be it. Somewhere in April, girl. April. I'll find it. I'll find the video, but it's somewhere in that neighborhood, probably April. Um the states, I feel like this is it. This is 16 pages. That sounds like that's probably it. April 21st. Um mm, 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 mm. because then there was some supplemental discovery. Let me see. Let me look at it. Is everybody eating lunch? We had an early lunch today. Okay. State's notice of filing supplemental. Hold on. Okay, it's coming up now. Okay, this is it. Is this it? Yeah. Okay, with the electronic signature. It was from this that I went and looked at that dealership. And with all that Westlake information, I'm sure that they would be looking into that dealership. We would have to go back to it. That document came out on April 21st. So I'm sure on the 21st or 22nd, I probably did a video. Anywho. Yes, I found it. I got it, Vicky. Thank you. Remember that Nesto basically said to Sonia that he was told that if he can't get the suppression, that he was toast. Okay. Hoover has to take this as far as he can before he will probably beg for a deal. Maybe not even beg for a deal. Let me tell you, I wanted to show you guys. We'll have to shut this one down and start up a new live. But there was a lady yesterday. I don't know if you guys watched it on Atlanta News First. There was a baby named Baby Grayson. Him and his mom were driving down the street in Atlanta, and the baby, just a little 1-year-old, guys, got hit by a stray bullet. Okay. This is what happened. Some bum and his new girlfriend he met on Instagram were driving down the street. And he was mad because his ex-girlfriend or some other girl he was dating went and slashed some tires, right? And they ended up meeting up with homegirl like in another vehicle. And do you know that the vehicles were shooting back and forth with each other? A stray bullet hit a baby. Baby passed away. This happened in 2022. This reminded me of the case last week, Julian Connolly, because it was like a stray, it was not a stray bullet per se, but it's a bullet that was meant. It was some shooting, illegal shooting, and innocent victim, right? The young lady was now being tried because the man, I think he LWOPed away. He's gone. He's in the penitentiary. Ma'am, the young lady who some wasn't quite right, but she has no criminal record. She was not here banging or anything like that. She was a girl. She just met this guy on Instagram and he was off the chain. Anywho, she's got a kid, or I think she has 2 kids. Anyway, she was trying to get some mercy. Baby, they sent her for 20 years. They gave her 20. She tried to get 10. She tried to say, "Can I have some time to get my affairs together?" The judge was like, "You're being remanded into the state of Georgia now. Like, you accept this offer, you're remanded. If you don't accept this offer based on your admission of guilt, you're being remanded and you can have your trial. Like, we're revoking your bond." Anyway, it was good. It was very interesting because I didn't really know anything about the case. But it was really, really interesting. So anyway, if you guys want to watch that, I will shut this down because I would like this to be a standalone, and then I'll come back and I'll play that for you guys. We could talk about it, but it was sad, but at the end of the day, the one thing the judge, these judges are so calm, cool, and collected. Um, she let her have it very, very cute, very dignified, very much with pearls on and her red lipstick, and was like, it was giving not really holding herself accountable other than, yes, I made some bad decisions. But the lady who lost her son, oh my God, she's like, she gave a very nice victim impact speech and they gave her 20 years, period. And she has to do all her 20. And she's lucky to be getting out because the judge, even though she begged for mercy, the judge was like, second degree, you're the prosecutors were generous by letting you have second degree on top of the fact you could be in prison for life without parole, like you could have gotten life. So for that, like, this is your saving grace. Like, you did get grace and you did get mercy. And it's the death of baby Grayson. Hold on, it was on yesterday. You guys, if you guys hang on, I'll run it back. It was the sentencing. And this lady's name, so there was a 6-month-old baby named Grayson. 6 months old, y'all. It was so sad. He got a stray bullet. And everyone else has been charged with the exception of this lady. She got her charge yesterday. This one right here. Hold on. Hold up. Portia's trying to chime in. It's like, girl, hush. She got her time yesterday. It was definitely not cute. And then they remanded her. This is the mommy. The daddy was on video. I don't know if he was at work and he couldn't take off. The dad spoke. It was very sad. There's the dad. He didn't even have words. He started crying. Very, very, very sad. The baby got a stray bullet. But this lady she was asking for, she had just met him like 2 months before on Instagram. And he had a crazy girlfriend or whatever, somebody slashing some. She said she was afraid that he was going to maybe shoot her. But based on the circumstances leading up to the random shooting on the streets of Atlanta, they're like, no, you going to take this 20. It was very interesting. Anywho, yeah. Okay, you guys, if anything else comes up about Nesto, you already know I will be back to let you know. There is a call out. Obviously, we did not see Hoover's motion for the appeal. Was it filed in secret? Was it filed hidden? I mean, what I'm going to say is, if Will Wooten gets to file anything about it, I'm sure he'll let us know, because Hoover does not mind filing a hidden document. Okay, he don't mind. Hold on, I'm just going to make it here. Okay, sorry, Farrah was texting me. Okay, you guys, if you guys want to watch the sentencing of that case, let me know now with like a 1. And I'll come right back. If not, then I'll see you guys later. You know what I mean? If you guys want to get back together, I can go live again. If not, it's cool. Okay, so you guys would like for me to run that? Okay. All of my court watchers, all of my trial watchers, are you here? Some of you guys like a good hearing. Okay. And we might be able to, depending on my time, because I do kind of have time. We could run the testimony of the girlfriend of Mr. Brandon Isabel, who's standing trial in Memphis for, you know, it's sad. It's very sad. It's a sad scene out here right now. Mr. Allen Speed, what's good, sir? What's good? What's good, Mr. Allen Speed? Thank you for supporting. Okay, so all right, I'll do 1:30. What is it? It's 1 o'clock now, right? We can do 1:30. I don't want to wait too late because it's gonna get too late. I got a shrimp po' boy that I can munch on. Okay. Thank you, Mr. Allen Speed. No need to any explanations over here. This is I appreciate it. But thank you so much for letting me know. I'm just glad y'all support, and I thank y'all so much. I saw some of the girlfriend that is also girl baby. Okay. Yeah, let's do like 20-25 minutes. I'm gonna go ahead and set it up so you guys can have the chat room. And then I'll turn it on in a minute, okay? So you guys go do what you gotta do. And if we get started without you, don't think any type of way about it. We love you, and there's always the replay, okay? Sometimes we gotta just do what we gotta do, okay? Replay is real, and just come when you can. It's grab and go, okay, boo? To all of my boo-boos out here, okay? You guys handle that business. If you're at work or have a meeting, all of that stuff, whatever we do, we'll be sitting right here waiting for you. If you are a member and you missed last night, sis was in a bad mood. I kind of got in a bad mood. Um, if you don't know, Nesto had a ministry visit from his ministry, Pastor Blabbermouth. I'm just gonna say it, Pastor Blabbermouth went over to go visit your favorite inmate, and baby, normally I can just laugh and it just rolls off my back. Pastor Blabbermouth got under my skin yesterday. I was like, are you kidding me? You're a court watcher? Yes, I am, Coco. Yes, if you're a member and you did not watch last night's member live, baby, you missed out. You might want to go check it out. Okay, you guys, if you are a Patreon member, just give me a little while. I'll post it up over there today. So that'll be available for all levels on Patreon. So I'll get you that today. So you guys can replay that. If you want me to, I can put it on a drop, but you guys don't really do drop over there. But, if you guys want me to put it on a drop, I can. Otherwise, I'll just post it and you can just, grab and go watch it. Okay. So if you're on Patreon, it'll be posted for you at some point today. Okay. All right, you guys. That's it for announcements. I'll see you guys in about 20-25 minutes. Okay. You guys take care, and I will see you later. Bye, guys.